Theft crimes in New York are known as larceny, defined as intentionally and wrongfully taking the property of another. Larceny is either a misdemeanor or a felony, usually depending on the value of the property taken or the type of property taken. The basic larceny statute is petty larceny and is only 11 words. A person is guilty of petty larceny when he steals property. Most often, petty larceny involves shoplifting, like a can of beer from the corner deli, Jean Valjean's loaf of bread from a baker, or a dress from a Macy's. Petty larceny is a Class A misdemeanor and is punished by up to 1 year jail or 2 or 3 years probation. If the charge is a first or second arrest, a prosecutor will likely offer an adjournment in contemplation of dismissal, known as an ACD, which is dismissed and sealed in 6 months, or disorderly conduct, which is a violation and not a crime and eventually seals. There may also be a requirement to perform community service or make restitution based on the value of the property taken. Unless the person charged has many criminal convictions, it is rare for a judge to sentence a person to jail for a petty larceny conviction. If the property taken is a ride on public transportation or in a taxi, or a meal at a restaurant, the crime is called theft of services, which is a Class A misdemeanor. Like petty larceny, a prosecutor will usually offer an ACD or disorderly conduct and may require paying restitution for the services taken, whether a restaurant bill or taxi fare, or performing community service. Grand larceny in the 4th degree, a Class E felony, is charged in a variety of circumstances. If the property is worth more than $1,000, a credit or debit card, a car or motorcycle, or if gained by extortion, the crime is punished by up to 4 years in prison or 5 years probation. Normally, if a purse or wallet is stolen, the crime is petty larceny. But if it contains a credit or debit card, the crime becomes grand larceny in the 4th degree. The same is true for an iPhone or a wallet that has some cash but no credit or debit card, which is removed from a person's pocket without force, often called grand larceny from the person. The degrees of grand larceny are related to value of the property. From the 3rd degree, a Class D felony for property worth between $3,000 and $50,000. The 2nd degree, a Class C felony for property worth between $50,000 and $1 million. And the 1st degree, a Class B felony for property worth over $1 million. Often, when larceny is charged, so is criminal possession of stolen property, which is simply knowingly possessing stolen property. If a person is charged with larceny and criminal possession of stolen property, it does not necessarily mean the punishment will be more severe. However, the two crimes are not always charged together. If police arrest somebody with stolen property, but there are no witnesses to the actual theft, then only criminal possession of stolen property will be charged. For example, a computer is taken from Starbucks when nobody is looking. If the person who possesses the computer is arrested for another reason, police may not have evidence of the theft, but may know that the computer is stolen from a police report. Like larceny, there are degrees of criminal possession of stolen property related to the value of the property, from the 5th degree, which is a misdemeanor, to the 1st degree, which is a Class B felony. Even if a person is charged with larceny or criminal possession of stolen property, there are important defenses that depend on the unique facts of each situation. And to repeat, if the person charged has never been arrested before, a non-criminal disposition is a possible outcome.